Welcome back to RR Corporates. Today we are going to discuss a very important topic in corporate law, the powers of the board of directors under section 179 of Companies Act 2013. While shareholders are the true owners of the company, it is the board of directors that acts as the decision-making authority and manages the day-to-day and strategic affairs of the company. Section 179 clearly spells how much authority the board has, where the limits lies, under what circumstances the shareholder approval becomes necessary. So by the end of this video, you will have complete clarity on the statutory powers of the board, the restrictions and limits, and the delegation powers, and the practical compliance requirements. The general principles under section 179 subsection 1. The board, section 179 subsection 1 lays down the foundation. It provides the board of directors can exercise all such powers and perform all such acts as the company itself is authorized to do. But there is one important condition. If any power is specifically required by the Act or by the Memorandum and Articles of Association to be exercised by the shareholders in a general meeting, then the board cannot take it up. So, in short, we can say that the board enjoys full powers of the management except those that are exclusively reserved for the shareholders. So now we will see section 179 subsection 2. So this subsection 2 of section 179 further clarifies that the board's authority is subject to the Companies Act and memorandum of association, the articles of association, and even the resolutions passed in the company's general meeting. However, such shareholder regulations cannot undo or invalidate acts already carried out by the board. Now comes the most critical part, specific powers requiring board resolution. Section 179 subsection 3. Section 179 subsection 3 read with Rule 8 of the Company's Meetings of the Board and its Powers Rules 2014 lists certain important powers that can be exercised only by passing the resolution at duly convened board meeting. Duly convened board meeting. These includes making calls on the shareholders in respect of unpaid share capital. Making calls on shareholders in respect of unpaid share capital. Approving buyback of securities under section 68. Then issuing securities, including debentures inside or outside India. Then borrowing money, investing company funds, granting loans, giving guarantee, or providing securities. Approving financial statements and the board's report. Diversifying into new business area. Approving amalgamation, merger, or reconstruction. Acquiring another company or controlling interest in making political contribution under section 182, noting appointments or removal one level below KMP, appointing or removing KMP, appointing internal auditors and secretarial auditors. So these matters cannot be approved by circulation. These matters cannot be approved by circulation. They must be decided in a formal board meeting and recorded in the minutes. And we'll move on to the delegation of powers. Delegation of powers. Delegation allowed. Section 179 subsection 3 allows certain powers to be delegated but with the strict conditions. The board can delegate powers such as borrowing of money, investing funds, and granting loans, guarantees, and securities. Delegation is possible only through a resolution at board meeting. Powers may delegate to committees, the managing director, manager, or principal officer of the company. Importantly, delegation cannot be done through circular. It has to be board meeting. It has to be board meeting decision. However, even when delegated, accountability remains with the board. Now we will see section 180, interplay with section 180. While section 179 covers general powers, certain special powers require approval from the shareholders through special resolution. For example, section 180 will see, for example, selling, leasing, otherwise disposing of undertakings, borrowing money beyond the aggregate of paid up capital and free reserves, remitting debt due from a director, and investing compensation amounts received from the merger or amalgamation. So, boards must check whether the matter also triggers section 180 before acting on it. Then we will see the practical compliances. So, board resolutions are mandatory for matters in section 179(3). Minutes of the board meetings must properly recorded. These decisions are for legal validity. Then MCA filings. Certain resolutions need to be filed with the ROC form MGT 14 and also reported in the annual report, annual return MGT 7. Delegation requires caution. Though allowed, it does not dilute the responsibility of the directors. Then corporate governance. Transparent use of the powers ensures compliance and protects the directors from personal liability. We'll also see the case laws, judicial and regulatory perspective. Courts and regulators have emphasized that directors act as a trustees of the company powers. In the case of Ramaswamy Iyer versus Brahmaya and Company 1966, it was held that directors must always use their authority in the best interest of the company. Even MCA circular. MCA has also clarified in its circular that resolutions under section 179(3) must be duly filed wherever applicable. Then conclusion. Section 179 confers wide powers on the board for effective decision making. However, these powers are not unlimited. They are controlled by the Act, articles, shareholders' rights, and governance principles. It is essential to ensure that board powers are exercised in line with the statutory provisions. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of our latest videos. Thank you.